May I invite Caroline Morris first to give our first presentation?
Okay. Well, thank you very much to the Trust for inviting me, and I'm very pleased to be here. And my topic today, I'm going to speak on the subject of prisoner and franchise. And what I wanted to start with is just to quickly outline the legal position that exists in a number of, exists internationally. And the concept of universal suffrage is one which features in almost any human rights document that you can name. The Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, the European Convention on Human Rights, and of course, closest to home, the Human Rights Act. But there is a disparity between these statements and what happens in actual practice. So these lofty statements don't mean that everyone can vote, of course, and states through law restrict voting rights of their people in a number of ways. And in the UK, voting rights are limited on account of age, expatriate status, second country national status, and prisoner status. And as I said, what I want to explore in my talk today is the legal context of prisoner disenfranchisement, and my colleague Alan is going to cover everything else, which sounds like a fair division of labour to me. So what I'm going to do in the next 20 minutes or so, I'm going to very briefly outline the cases in the last decade which have challenged the UK's prohibition on prisoner voting, and then I'm going to look at a range of issues focused around the question of does it matter, because it seems to me that it's quite difficult to answer the question that's been posed by the Trust, and that is, does the extent of the franchise influence the outcome? So I'm going to ask a slightly different question of, well, does it matter? So I'm going to look at practical issues of electoral administration. I will look at the legal consequences of the two foremost cases on prisoner voting, Hurst, which has a degree of infamy now, and Delvine, a very recent decision that came out last week. And then lastly, I will look at the arguments relating to legislative reform. So, as I've said, prisoner voting is prohibited in the UK, and that's found in Section 3 of the Representation of the People Act 1983. That itself was a consolidation of an earlier prohibition that was put in the Representation of the People Act 1969. Now, I just wanted to mention at this point that prior to 1969, there were periods when prisoners were enfranchised, and secondly were at a practical level able to vote. So prisoner voting has at some point featured in the UK's legal history. Now the interesting thing from a legal perspective is that the ban on prisoner voting in the UK is a blanket ban. So it makes no distinction as to the length of sentence served, or the type of crime, or the gravity of crime. It prohibits voting in parliamentary and local elections, and of course it was in place for the general election 2015. In addition, I just mentioned that prisoners were not permitted to vote in the Scottish independence referendum, and specific legislation was enacted by the Scottish Parliament to ensure that, and it seems from a reading of the European Union referendum bill that prisoners also will not be able to vote in the upcoming Brexit referendum. So, given that this ban has had a reasonably long pedigree in legal terms, it's surprising that challenges didn't really gain much steam until the second half of the noughties. And the case that I want to focus on first, that really began us down this path, was decided in 2005. So Hurst was a prisoner who'd been sentenced to life imprisonment for manslaughter, and he claimed in court that the ban breached Article 1 of the third protocol to the European Convention on Human Rights. Now, there actually is a duty on states to hold free elections, but jurisprudence says that does include a right to vote. The Grand Chamber of the the European Court of Human Rights, did agree, or majority agreed, and held that there'd been a violation of rights. Now, what they said was, quite interestingly, they said that voting rights could be limited. So immediately they acknowledged that this particular right could be limited to some degree, but the particular approach that was taken by the UK was unacceptable because it was too general and indiscriminate. So as soon as you achieve prisoner status, you are prevented from voting. Now, at the time of the judgment, 18 European states completely enfranchised prisoners. 13 completely prohibited it, primarily the emerging democracies of Eastern Europe, and 12 occupied a middle ground. So there was quite a wide range of approaches to prisoner enfranchisement. Now, following Hearst, which was a case at international law, there was then a domestic challenge which Hearst opened up scope for, and this was a case from Scotland. It was called Smith and Scott, and there the court assessed the compatibility of Section 3 of the Registration of the People Act with Article 3, Protocol 1 of the European Convention. And what they did there was to make a declaration of incompatibility under the Human Rights Act. Now, this declaration is exactly what it says. It doesn't have the effect of invalidating the law. It doesn't require Parliament to take any action. It doesn't require the government to take any action. But it obviously has this symbolic value of the judiciary notifying the democratic branches of government that they are in breach of human rights law. And this was the first, but also the last time a declaration of incompatibility was issued. So that was in 2007. The government didn't amend the Registration of the People Act, either under the remedial orders provision of the Human Rights Act or through primary legislation. So what did happen? In February 2006, after the Hearst decision came out, the government announced that it would begin a consultation on prisoner voting rights. This didn't begin until December 2006, and it didn't conclude until 2008. But what it did do was put forward a range of options for changing the law. And these were these followed on from the indications in Hearst that the European Court would find some middle ground acceptable. So there wasn't the stomach for full prisoner enfranchise, but some limited degree of enfranchise was going to be acceptable. Then there was a further round of consultation on that in 2009, but no legislation appeared before the general election in 2010. And it seems that this was unlikely to have been a coincidence. I've found a lovely quote in the House of Commons, a research note from Jack Straw's autobiography, where he said, "In my last ministerial post as Justice Secretary, I'd made many decisions about many things, but I'd also spent 3 years ensuring that the government took no action in response to a judgment by the European Court of Human Rights that the UK's ban on convicted prisoners voting was unlawful. I'd kicked the issue into touch, very apt with all the rugby season at the moment, first with one inconclusive public consultation and then with a second." So, nothing happened there. But what did happen, so no action really, real action on the political front, but on the legal front, steam was beginning to build because with this decision from the European Court and the Scottish Court making a declaration of incompatibility, thousands of applications were being lodged challenging the blanket ban. So matters came to a head in a case called Greens and MT. This was from two prisoners who hadn't been able to vote in the 2009 European elections or the general election 2010. And of course, on the same facts, with the same law, unsurprisingly, the European Court of Human Rights came to the same conclusion. They said there's been a violation of the right to vote in the Convention, and this is because of the UK's failure to implement the judgment in Hearst. So there was a direct connection between this finding and the earlier finding 5 years ago. As a result of this, the UK was given 6 months to amend the Registration of the People Act, and in return, the European Court said that it wouldn't hear any more of these clone cases until the UK amended its legislation. So we stop the pressure building up in return for sorting out our lack of compliance with this judgment. And so in November 2012, the government did publish a draft bill, and this was the Voting Eligibility Prisoners Bill put it for pre-legislative scrutiny from a joint committee of both houses. The report of the committee came out in December 2013 and said that the vote should be granted to all prisoners serving a sentence of less than 12 months. Probably a surprise for the government because this wasn't one of the options that was actually in the bill. They had said that there should either be a ban for prisoners sentenced to more than 4 years, more than 6 months, or a ban for all convicted prisoners, which was just a restatement of the existing law. The committee said that this had no basis in logic, unlike the 12-month period, which did have a legal basis in the Forfeiture Act. Now, I just note that before the committee's report came out, the Supreme Court heard another voting rights case, and this is called Chester and McGough, I think. And they had taken the challenge, not under the European Convention on Human Rights, but they had taken the challenge on the right to vote in EU law. And the Supreme Court dismissed this. They said there is not this parallel right to vote under EU law, which is very interesting given the position that we find ourselves in a few years later, and which I'll come to soon. So the coalition government did not respond substantively to the Joint Committee report. It did not bring forward a bill in the 2014 Queen's Speech. And in December 2014, they said that the ban on prisoner voting would be in place for the general election 2015. Now, lastly, I just want to mention that also in 2014, there was a case called Muin. The UK Supreme Court dismissed an appeal from a Scottish prisoner relating to the Scottish referendum, which of course had passed, saying that the European Convention law didn't cover referendums, but interestingly they also said there was no common law right to vote. So the right to vote can only be sourced in statute, according to the Supreme Court. So here we are, 10 years on from Hearst, and nothing concrete has really materialised. What I want to ask now is, well, does this matter? And I should just state at the outset of this section of what I'm going to say that I am in favour of prisoner voting. I'm in favour of complete enfranchisement. It doesn't seem to me that there are practical or legally sustainable reasons for denying prisoners the vote. So that is the context in which I am going to make the following statements. So first of all, a practical perspective. How many prisoners are there? So I looked up the most recent statistics that I could find say that there are about 86,000 people in prison this week. If we take out those on remand who are untried, which is about 8,000 people who are able to vote, and we take out those under 18, about 1,000 who are not able to vote in any event, we've got about 77,000. The number of electors, and I've taken the Office of National Statistics figures from December 2014, 45,325,000. So, looking at those numbers, if all prisoners were enfranchised, by my very rough maths, they would comprise about 0.2% of the electorate. If we enfranchise prisoners serving sentences of less than 12 months, along with the Joint Committee recommendation in 2013, that's about 6,000 people who would be enfranchised. That's 0.01% of the electorate. And if we enfranchise those serving sentences of less than 4 years, which seemed to be about what the previous government was able to contemplate, that's about 29,000, but those are on the 2009 figures. I wasn't able to get anything more up to date than that. That would be 0.06% of electors. So these numbers are, by anyone's calculations, minuscule. And I can't see how they would have any discernible impact, even if all of these people actually voted, which is a secondary issue, that it would have any impact on the outcome of elections. So I cannot see that prisoner prisoner enfranchisement would have any influence on elections. Sometimes objections are raised that granting prisoners the vote would be logistically difficult, but I think this can be dealt with via postal voting, and postal voting was in place for prisoners and was used in the 1950s. So we have a precedent there. It's also sometimes said that enfranchising prisoners will have a disproportionate impact on the constituency in which a prison, particularly a major prison, is located. But again, I think the impact of this can be avoided by not enfranchising prisoners in the electorate in which they reside, but in the one in which they were last registered in, or where they have some form of local connection, and there is provision in election law to allow for that to happen. So I don't think that practical objections to prisoner votings can be determinative of the matter or explain the reluctance to enfranchise them. So what I want to do now is have a look at 2 decisions on prisoner voting and ask, what are the consequences of them? Why does it matter that there's been so much litigation, and there have been a lot more cases than the ones that I've highlighted, and does it have any impact on our legal reform programme? So first of all, Hurst. So this was a decision of the European Court of Human Rights. And as a matter of international law, the government is obliged under Article 46 of the European Convention to implement the decisions of the European Court. But critically, this obligation does not apply to Parliament, and it does not apply to the judiciary. So we have an imbalance there in our political system. All of the obligation lies on the government, and as we've seen, they don't have the political will. So what can the European, or the Council of Europe, whose treaty the convention is, do about this? The Council's Committee of Ministers monitor implementation of decisions, and the UK over the past decade has been constantly corresponding with the committee, saying, well, we're doing something. We're engaging in consultation, we've got this draft legislation, we are waiting for a report, we are waiting for the outcome of another case that's coming before the Council before we decide what to do. So there has been a lot of busy work, but nothing really tangible in terms of implementing the decision. The most the Committee of Ministers can do is keep nudging government towards compliance and hold out the ultimate sanction of suspension or expulsion from the Council of Europe, which to me seems unlikely, given that I think they haven't expelled anybody since Greece in the 1970s, I think. Or, of course, the UK could withdraw from the convention. But legal sanctions simply do not exist. So there is no push, no ability of the Council of Europe to require governments to implement their decisions. So the decision in Hurst, groundbreaking though it was, given that it spawned a lot of clone litigation and other cases challenging prisoner voting rights, has not had the impact that perhaps we might have thought, and that is because of the structure of the Council of Europe and its legal powers. So that is 10 years. Very neatly, prisoner voting has been bookended by a case that came out last week, and that's a case called Delvine. It's a French case, and it involves a convicted murderer in France who challenged the French ban on prisoner voting from voting under EU law. So this is not a Council of Europe case, but a European Union case. And the ban in France included voting for elections to the European Parliament. So the European Court of Justice said that measures in domestic law that decide who can vote in European Parliament elections do fall within the scope of EU law. This is very important because the European Charter of Fundamental Rights, which is effectively a facsimile of the European Convention on Human Rights, only binds member states when they are implementing EU law. So the court first had to find, is this a matter of EU law? And they decided that it was. And so therefore this means that Article 39 of the Charter kicks in, and this guarantees the right to vote. Now, interestingly, the ECJ, similarly to the court in Hurst, held that you could limit the right to vote. So they did not say that prisoners must all be enfranchised. But what they did say was that any limitation on the right to vote has to be proportionate. And by that legal test, they mean that it had to pursue a legitimate aim. And it has to take into account, when imposing a penalty in the form of limiting a right to vote, the nature and gravity of the offence. Okay, so this means, for our purposes, that general, automatic and indiscriminate bans, such as the one in the Representation of the People Act, are in conflict with EU law. This has a lot of significance for what the obligations for us are, because EU law prevails over inconsistent national law. So all UK courts are under an obligation to ensure that rights under EU law are respected. So I think that as a result of this case, it's quite likely that we will see a challenge to the ban on voting, at least in European elections, because that is the link between the domestic law and the Charter of Fundamental Rights. And it is quite possible that a court would feel empowered, based on occasions where it's done similarly, it could disapply that provision of our law. Now, of course, that is a major threat to parliamentary sovereignty, and there is a lot of debate in the academic literature about what Parliament might respond or how a judge might respond. There's also the possibility that the European Convention might issue infringement proceedings against the UK, which might itself lead to the UK being fined for lack of compliance. So the tools for securing compliance with the right to vote are much stronger in this case, and this is because of the nature of EU law. I think it's very interesting also that our Supreme Court had denied that the right to vote was a matter of EU law, and they've obviously been overridden on that. Right. So how might we reform the law? Of course, just to restate that I think that all prisoners could be easily enfranchised without any legal trouble. But let us assume, I think, on a fairly solid basis, that the government doesn't have the intention of doing that, and that they will only implement some form of limited ban. So this means that we must comply with the principle of proportionality. There must be first a legitimate goal.
From Cambridge, right at the end, you did finally come on to the area which concerned me, which is that there are offences from which voting is specifically banned, and the usual period is actually 5 years, which seems you didn't mention, for various practices, of which corrupt practices are one. Has that even been discussed in the legislation?
Has the 5-year period received any, or the corrupt?
The fact that specifically voting or civic rights generally, including standing as well as voting, can be debarred for a period, and it's usually 5 years. I think it may be 3 years for some rights.
I think it depends on whether it's a corrupt. I think you're right. 5 years is for corrupt practices and 3 for illegal. I'm not sure that there's been any sustained examination of the question, because, as far as I can tell, the focus has been on this very blunt alignment of sentence length with as a substitute for actually analysing. I think I've seen a few references occasionally to corrupt electoral practices leading to disenfranchisement, but I haven't seen any sustained.
A few convictions, because election courts don't have a power to send people to jail, or just to remove them from office.
I don't know if anybody who's a bit
it's
closer to the issue.
It's like a driving ban, isn't it? It's a specifically targeted sanction arising from a particular category of offence. I think it stands alone in its own right.
I don't think I've seen any. I don't think I personally haven't come across anything that looks at that as a viable alternative to just taking a cut-off point in sentencing.
I'm surprised you don't see a link between imprisonment and denial of the specific civic right of voting, because most other civic rights are removed during a sentence as well.
But not all of them. I mean, some of your rights do live. So you do have rights to privacy, to your correspondence, to be able to engage with lawyers. You do, of course, have the right to be free from torture and inhuman treatment. You do have rights to natural justice.
That's why they use the term civic rights rather than the broader human rights.
Okay. Well, I still think that voting rights to me I don't think seem to fit with rights that might naturally be limited due to the nature of your imprisonment. I'm open to being persuaded otherwise, but
Voting is ordinarily a matter of going to a polling station, which is difficult to do as a prisoner.
But I think that we can get around that. We have provisions. Not ordinary citizens don't have to go to a polling booth, so I don't see why.
Going back to the common law principles, even if it's not covered in common law, postal voting is a modern invention. Voting is older than that.
Well,
Can I call a pause on this particular debate? There's one other. Is it a factual point
yes,
at the back?
I wondered if the
Can you give your name?
I'm Nigel Cederer. I wondered if the parliamentary committee that looked at the possible compromise position had considered whether it's right to allow prisoners to vote for people who will be in office, but whose term of office will end before the prisoner's release. So that would seem to me to put a 5-year sentence to have some rationality.
I'm not sure, but what I can give you as that is actually the position that used to exist in New Zealand, which is actually where I'm from, and there was limited prisoner enfranchisement, and there the ban on prisoner voting was limited to those who are in prison for 3 years or more, and in New Zealand there is a 3-year electoral cycle, so it was very closely tied to the idea that you should be able to vote for people who are going to be in power when you are released. So there's overseas consideration of that, but again, I haven't come across that being seriously considered here.
I'm a bit concerned to move on to our second speaker. So may I ask? I can see several
Given that
hands.
you have everything
Are
else
you
to
willing
cover.
Are you willing to be patient so we can have our second speaker and then we can open it up to everyone? If that's all right. Okay.
Shall I go for it? Thank you.
Thank you very much.
I hope you don't mind if I stand up because I'm going to use the screen.
Do you want me to press
I
the...
can do it.
Okay.
It's okay. That's fine. I should ask her. Oh, we have a roving mic thing. Do you want me to use cameraman? Should I?
I'm not sure if that cable's going to reach, but it will pick you up anyway.
So I'll just
No,
leave
you
it
don't
there.
need to. Yeah.
Okay, great. So I need to start with a confession, which is that our subject today is one about which I know very little. And insofar as I do know anything, that is due to the excellent work over the last few weeks of my research assistant Barney, who is sitting at the back of the room. All difficult questions that you might ask later will be directed towards Barney. But when Paul asked me if I would come today to speak on this subject, I said to him, well, I don't know terribly much about the franchise, but the franchise is an issue that we in the Constitution unit have identified as one that we need to investigate further. So would you mind if I came along and offered some introductory basics in order to stimulate some discussion of the topic from which I would benefit as much as you do? So that is essentially the sort of talk that I am going to give you here. So I hope we're going to have time for discussion at the end. So the question that Paul has set us is who can vote? Does the franchise influence the outcomes of referendums and general elections? And in a sense, the answer to that question is, well, obviously yes. If we banned from voting everyone under the age of 70, then that would make quite a big difference to the to the outcome of elections, for example. Clearly what the question means is, do the sorts of aspects of the franchise that are currently up for debate make a difference? And I think there are 4 aspects of the franchise that are currently up for debate. One is the idea of reducing the voting age to 16. Second is the one we've just been discussing. Third, the question of which foreign nationals who are resident in the UK should be able to vote. And the last is which UK nationals who are not resident in the UK should be able to vote. So I'll attempt to say just a few quick things in relation to three issues on these. First is the issue of how the UK compares with other countries. So a quick survey of what's going on around the world on these issues. Second is the question that we were set of how the rules affect outcomes, and what do we actually know about that question? Rather little, I fear, but that's the second question. And then finally the question of what other questions are relevant for our thinking about what the franchise ought to be. So, in relation to the first issue of franchise rules around the world, we'll start with votes at 16. And so I often do comparisons looking at 45 stable, well-established democracies around the world. If we look at those 45 democracies, we find there's not much variation in the age of voting. 43 of them have votes at 18. One of them only, Austria, has votes at 16. One, Japan, has a higher voting age, but they have actually just voted to lower the voting age to 18 from next year. So Japan will disappear from there. So we don't have much variation in that set of cases. There's a little bit more variation if we look further. So first of all, there are some more countries that were in that chart there do allow voting at 16 for some people or in certain elections. So there's some variation going on there. There are also some other countries that are not in my set of stable and well-established democracies. These obviously are stable and well-established democracies, but they're not fully sovereign countries, so I put these in that category as well. There are also a few countries that have votes at 70, for no very obvious reason. North Korea. Great democracy. So that's the basic situation around the world on that. With regard to prisoner voting, so there are two issues actually here. One is the issue of what prisoners can vote. Is it none of them, some of them, or all of them? And there's also the issue of what ex-prisoners can vote. And there are restrictions in some countries on ex-prisoners as well. So the UK, as we know, is a country in which no prisoners can vote, but once you're ex-prisoner you can vote. Whereas most European countries either allow all prisoners to vote or at least some prisoners to vote. There are a few places, some of the particularly southern American states, in which prisoners cannot vote, and once you've been released from prison, you cannot vote for the rest of your life. There are also a few countries in Europe in which some former prisoners are restricted from the right to vote. Just to give a little bit more information on some of the countries in the some categories there. Several countries have the sorts of restriction that Caroline was talking about, where there's a length of sentence-based restriction. So Canada, if you're sentenced more than 2 years, Malta, if you're sentenced for more than 1 year, then you lose the right to vote while in prison. Luxembourg is a particularly intriguing one. So if you're sentenced for more than 10 years, then you lose the right to vote for life. If you're sentenced for between 5 and 10 years, then with some discretion for the judge, you can be disenfranchised for up to 20 years, so including some of the time after you leave prison. Third issue is the one of foreign nationals. I struggled to find a good picture for that. So the general rule is that voting rights are related to citizenship. There are various deviations from that. So the most familiar one is perhaps that EU nationals resident in other EU countries can vote in local elections and in European Parliament elections. Some countries extend that provision regarding local elections to residents from other countries. And, of course, there are various special rules regarding former colonies. The most familiar of those being, of course, that Commonwealth citizens resident in the UK can vote in UK elections. We're not unique in that. In Portugal, for example, Brazilians who are resident in Portugal can can vote.
And there's the Irish.
And then there's the Irish. So Commonwealth and Irish residents in the UK.
The Irish rights are more extensive.
Yes, sure. There are more open provisions than that in just a few countries. So from my set of 45 kind of long-established democracies, I could identify, Barney could identify, 3 countries in which there are provisions for non-citizens to vote in national legislative elections. So Uruguay, but you have to live there for 15 years. Chile, after 5 years. And by far the most permissive is New Zealand, where you need to be resident for just 1 year, if I understand the rules.
That's correct.
In New Zealand. And then final issue is nationals living abroad. No, I got that one by Googling retire to Spain, so I think it's clearly not going. So, again, we have 3 categories. Countries in which no nationals living abroad can vote, those in which some can vote, and those in which all can vote. So we're in the middle category because you retain voting rights only for 15 years after leaving the UK. Greece, so you can...
Greeks are required to vote in Greek elections.
Yes.
Wherever they're living.
So, so long as you retain, I think I'm right in saying, so long as you retain a residence in Greece, but you have to return to Greece in order to vote.
No, I know some Greek citizens that have to vote.
You certainly don't have to vote if you don't live in Greece. Barney's shaking his head, so I'm feeling confident. Okay, so that's a very quick survey of the situation around the world in relation to these issues. Now, the question of what effects do these things have? So we have our 4 aspects of the franchise that are up for debate. The prisoners one is the one that Caroline has already talked about, and she's already gone into this in much more depth than I have. So we've got the same number of prisoners. I didn't do Caroline's sophisticated analysis of breaking that down, but if you, just another way of looking at that number, is if you take all of those, and Caroline correctly pointed out that some of those have the vote and some of them those are already, and some of them are below 18. But if you just take that full number, then you end up with 132 people per constituency. There were only 3 constituencies in May where the majority was under 132 votes. So that's another way of illustrating the lack of importance of this point to the outcome of elections. On 16 and 17-year-olds, the latest estimate is about 1.5 million 16 and 17-year-olds. If you divide that by 650, then you get 2,360 of them per constituency. And 56 constituencies had a majority in May of less than 2,360. So that kind of puts an upper limit on an extreme upper limit on the number of places where you could conceivably have a difference in the result based on the enfranchisement of 16 and 17-year-olds. But of course that presumes they all vote, and they all vote for the second place candidate. So that's a fairly extreme set of assumptions. Foreign nationals, their latest estimate is over 5 million foreign nationals living in the UK, which is rather a lot per constituency. Some of those are already enfranchised, of course, for local elections. Some of them are already enfranchised for Westminster elections as well. And finally, estimates on the number of UK nationals living abroad vary very widely. The 13 million figure is one given in a written answer in Parliament by the Minister a few years ago. The 5.5 million one is one produced by IPPR a few years ago. I have no idea which of these might be more accurate. One of these estimates suggests 2.2 million of those live in other EU countries. And of these people in 2015, just over 100,000 were actually registered, which is a big increase in past years. The Electoral Commission thinks that's probably because of the introduction of online registration. So a very small proportion of these people have actually been registered. And therefore, in past elections, they've made very little difference. Of course, whether the registration rate will go up when we have the EU referendum is an interesting and important question. But at the moment, only those who've been outside the UK for fewer years than 15 are able to vote.
We don't know what proportion of those members.
No, I couldn't find that. I doubt that exists. So that's a very initial indication. Now, of course, we wanted to know a bit more about how might these people vote. And I can find very, very little research on that. Obviously, you can't really do research on prisoners because there's so few. I can find very little research on foreign nationals and nationals abroad also. We can speculate, but I can't find any detailed research on that. There is, however, a bit of research done in relation to 16 and 17-year-olds. So there's quite a long tradition of research in political science in considering the issue of whether the voting age should be reduced to 16 or 17. And the general idea in that literature is that if you're concerned about issues of turnout among 16 and 17-year-olds, and if you're concerned about the quality of the vote that they might cast, the degree to which that's a knowledgeable vote, then much really depends upon the quality of citizenship education. And so long as you have good quality citizenship education, then it's certainly not going to cause a problem to reduce the voting age, and in fact you might improve participation in elections if you enfranchise 16 and 17-year-olds, because there's a clearer connection in time between learning about politics and actually engaging in the act of voting. If we look at experience in actual votes, so there is of course the experience of the Scottish referendum, participation seems to have been high and active. I say seems because although the media often make rather brave claims about exactly how 16 and 17-year-olds voted in Scotland, none of the surveys that have been done on this have specifically sought to sample 16 and 17-year-olds, and therefore the sample that they're extrapolating from is really, really tiny. So, if you do the Electoral Commission research, for example, had a sample, if I remember, of about 1,800 people in total. They don't say what the proportion of 16 and 17-year-olds out of that is, but it's going to be a few dozen. It's not going to be much more than that in that overall sample. So you've got to be very cautious. But the Electoral Commission research suggests, if you believe it, that turnout among 16 and 17-year-olds was higher than among 18 to 24-year-olds. Lower than the average overall, but higher than among 18 to 24-year-olds. And similarly, those people seem to have understood the issues and were very actively engaged in the issues. And there is evidence that those where their school had some kind of event related to the referendum were more engaged and understood better, which relates to that point about citizenship education being quite important. The country from which we have most evidence is Austria, which introduced votes at 16 for all elections in 2007, and there's been some serious academic research done on 16 and 17-year-olds. So one thing that they have looked at is shown in this rather ugly graph, which you can't see, but the squiggles there show levels of engagement with various political activities, contacting politicians, collecting signatures, working for NGOs, demonstrating, working for election campaigns in different age groups. So the age groups are 16 to 17, 18 to 21, 22 to 26, 26 to 30, and then 30 and above. So what you can see essentially is that there's a very clear pattern. It's not the case that 16 and 17-year-olds are very different from anyone else in that context. Some previous studies done in other countries have found low levels of political engagement from 16 and 17-year-olds and have concluded, 16 and 17-year-olds aren't engaged with politics, better not give them the vote. Well, of course, they don't have the vote, so you would expect them to be not very engaged in politics. But this is evidence from somewhere where they do actually have the vote. So the evidence there is that
Levels of general political engagement are broadly equal between 16 and 17-year-olds and others. Quality, sorry. Quality of political engagement is broadly the same, so knowledge of political topics, the degree to which people's self-placements on a left-right scale match their whom they're going to vote for, these sorts of things are pretty similar across age groups. And turnout is slightly lower than the average across the population as a whole, but again seems to be a bit higher than among the next age group, the 18 to 24-year-olds. And we don't have terribly much more evidence than that, to be perfectly honest, on exactly how these decisions would affect voting. So, finally, very quickly, what other criteria might we want to think about for deciding the franchise? This is where I go way beyond anything that I know about, okay? But just looking at the debates that have been taking place in the UK in particular, the sorts of things that people seem to care about are partly criteria related to individual rights. So there are, I didn't put in rights, sorts of rights that are important in the prisoner voting debate, because I knew Caroline would do that much better than I can. But in relation, for example, to the question of the voting age, or of whether EU nationals should be able to vote in the EU referendum, one of the big issues is to do with to what degree and in what ways are people affected by these decisions. So the idea of no taxation without representation is often applied to 16 and 17-year-olds who are paying taxes. The idea that EU nationals living in the UK are deeply affected by the UK's decision on EU membership is often discussed in relation to this point. Another aspect of individuals' rights is individuals' community membership. So the notion of citizenship actually being something that matters, and citizens have certain rights that non-citizens do not have. There are often also arguments that your right to vote is influenced by your competence to vote. So, much shaking heads, that 5-year-olds do not have a right to vote because they're not competent to vote is an argument that is certainly often voiced by those arguing against lowering the voting age. Similarly, an argument that is often given in relation to overseas voting is that if you've been away from the UK for a sufficiently long time, then you may just not be sufficiently connected with enough to speed on what's happening in order to be able to vote. Then we have criteria related to the strength of democracy. So the sorts of concerns I was mentioning in relation to votes at 16 about levels of participation, would lowering the voting age lead to lower voter participation? And a particular concern there is that there's lots of evidence that whether you vote or not, the first time you're allowed to vote makes a big difference to your voting behaviour for the rest of your life, and the likelihood that you will subsequently vote. So there's a concern that if people are enfranchised at an age when they're less likely to vote, that may reduce participation across the lifespan. The quality of democratic participation often comes in, again, related to that point about there, and concern that we need people making decisions who understand the issues and are going to make good and sensible decisions, otherwise we collectively suffer. And then a slightly different sort of point, and a more kind of political point, is concerned about the manipulability of the rules. If you have franchise rules that can subsequently be manipulated by politicians in order to influence who wins, then that's a problem. So, for example, if you have restrictions on which prisoners can vote, you can then change sentencing rules in order to affect who has the vote. If you have some kind of principle that says that whoever is influenced by a particular referendum vote, say, in particular ways, should be enfranchised, then that kind of opens up the question of the franchise every time you have a vote, which makes political manipulation of the decisions rather likely. So you might want to avoid that. And then other criteria may also be important. So criteria relating to national integrity, criteria relating to prisoner rehabilitation, as Caroline was discussing, and many other things could also be put in here. Caroline mentioned practicalities, for example, the question of our relationship with other parts of Europe through various institutions might also matter. That's definitely enough from me. I hope there will be lots of interesting discussion so that I can learn more about this stuff.
Sorry, my name is Isabel White. I work in the House of Commons. Can I just throw something in? The government has said that they're going to introduce a bill this autumn, although we haven't seen it yet.
Okay, so, well, the evidence that we've got from the past is that rates of registration among expat voters are very low, and it would be reasonable, I would have thought, to hypothesise that they would be particularly lower but among those who've been away for longer. But, of course, the joker in the pack there would potentially be the EU referendum. My understanding is that, as Caroline said, they're not planning to... No, you didn't say, but... Sorry, as Caroline might have. They're not planning to enfranchise that group for the EU referendum. If they did, then that would be a vote that many people, at least in the EU, might want to engage in, and that might kind of have a trigger effect in leading to higher voting subsequently. But if that sort of trigger is missed, then my hunch would be that you would continue to see very low levels of participation until there was a vote that really, really mattered to these people. And so after such a vote, that either participation would revert back, or there might be a somewhat raised level thereafter because people would have kind of got the idea that this is fun.
Some countries have dealt with this by having members that specifically represent overseas voters, like France.
Yeah. Yeah. And they also find, on the whole, very low rates of turnout for those districts. And the fact that there are specific representatives, part of the idea of that is to raise turnout, because they're their representatives. You're not just a little pool of a few people in a constituency that otherwise is very different. But even there, you get very low rates of participation.
If I could just follow on from Alan's comment. I find myself in quite an anomalous position. I'm a second country national in the UK. I'm permitted as a Commonwealth citizen to vote in UK elections, but I'm actually disenfranchised in New Zealand because I have been out of the country for too long. So I haven't been home in 5 years. And I've got to go back every 3 years to retain my right to vote in New Zealand, so I've lost that at the moment. So I wasn't able to vote in the last general election. I'm not going to be able to vote in the referendum on changing the flag. And I wanted to pick up on the comment that you made about the justification for that, and the idea that when you've been away from somewhere for some time, 3 years, 15 years, or whatever, you lose your connection to that country. You're not aware of political debate or awareness and so on. And I think that while that argument might have had more force in the days before the internet and international travel, I think that has really lost its force somewhat, because it's much easier to keep up with political activity in another country. You might not be as engaged, but I think you can remain engaged, and I think we start getting into making difficult qualitative assessments about how well you're keeping up with what goes on back home, as it were. So I'm quite interested to see that the UK is moving away from disenfranchising citizens who've lived abroad for too long. I think that's an interesting legal development there.
Yes.
Sorry, the one I sort of saved up from
yes.
for Caroline. My name's Lewis Baston. I research in elections and things. The question was sort of whether it would be compliant with the various judgments if instead of a general lifting the ban, the government moved towards some sort of system where the trial judge decided, and then through sentencing guidelines or not making a form available to give a voting permit to prisoners or whatever. They try to make it as hard as possible through that means. Would that be compliant with the judgments that have been made?
In short, yes, I think so, because the European Court of Human Rights in Hurst said that one of the things that was lacking from the UK was an individualised assessment, and so that could be done through sentencing, and it could be done through the individual judge. So you could introduce sentencing guidelines that would give you a range of criteria that you would look at and make that assessment. I have some reservations about that, just purely from consistency point of view, but it is certainly legally possible to comply with those judgments by doing it through the judicial process rather than the legislative process.
Okay, thanks. May I have one for
Go on.
Thank you. Yes, one thing that came across in the debate about voting 16 a few years ago, certainly, was that a piece of evidence was brought forward that actually the proposition wasn't very popular in opinion polls of the existing electorate. Now, it seems to me that what the existing electorate think of possible sort of new members of the electorate is, in terms of principle, is absolutely irrelevant. Either justice or otherwise of women getting the vote was unaffected by what enfranchised men thought about it, for instance. And yet it seems to be sort of quite a persuasive argument among some in the debate, if not to sort of, even if it doesn't correlate with any of the principles you have.
Yeah, I would agree with that, and I would add that it's not an issue that the public have thought about. So it's the sort of issue where you get very, very different responses in different opinion polls depending on the immediate context, depending on how you word the question. In Scotland, the research that was done in follow-up to the referendum asked everyone, not just 16 and 17-year-olds, whether they thought it was a good idea for 16 and 17-year-olds to have the vote, and there was a big majority. I think it was 60% in favour, because the discourse at the time was saying they're participating very well. So I agree with you that in principle that's not a good criterion, and in addition it's not a criterion where there's a sensible view anyway, or a thought through view.
Thank you. John here with a couple of questions on the votes at 16 or not. I'm haunted by the fact that as a teacher I have a very good student who celebrated his 18th birthday the day after. One or two quick factual questions. Will 16 and 17-year-olds be able to vote in next year's parliamentary election in Scotland and in Wales? And or, given the new powers being given to Scotland, will it be able to vary the right to vote in British elections, or is that still something to be decided? My main point is this: I'm broadly in favour of vote 616, not least for the reason I mentioned a moment ago. But I have got a problem. That is to say that the turnout between 18 to 24-year-olds is consistently below those of their elders, not least that is the 65 plus. And what worries me is if we uniformly reduce the vote to 16, then it might actually be somewhat embarrassing if that fails to significantly increase turnout. In other words, if the youngsters continue to vote with less enthusiasm than their elders, then what's right? Put bluntly, if that is, there's a real head of steam amongst the 18 to 24-year-olds to vote, then I think the logic is there. But as long as they're not showing that enthusiasm, that frankly creates a problem for those saying reduce the voting age.
Shall I? So on the matter of the devolved assembly elections next year, the Scotland Act will give the Scottish Parliament the power to decide the franchise for Scottish Parliament elections, and the SNP will certainly intend, as would Labour if they miraculously got back in Scotland, they would reduce the voting age to 16, but that won't be in place in time for the Scottish Parliament elections.
It will.
Oh, it will?
Yes. The Scottish Parliament have legislated already.
Oh, okay.
Reduce the voting age and it'll be in place for next year's parliamentary elections. local government elections in Scotland in 2017.
Okay, fantastic. Right.
Wales there's a draft Wales bill that just come out this week, and it looks like they're going to be given the same rights
In time.
And on your second question in relation to the fact that turnout is low among 18 to 24-year-olds, and yes, that's clearly correct. And the concern in the past has always been that if you enfranchise people at an even lower age, then you would have even lower turnout. The evidence from Austria is that that's not the case. The evidence from Scotland is also that that's not the case, but that was an unusual sort of effect. But so the evidence from Austria is more useful. And also we should remember that you can have quite a big influence upon that through the quality of citizenship education. And if you have really good citizenship education, then the expectation is, again, there's not a lot of evidence on this because not many places have tried it, but the expectation is that you can counter any reductive effect upon turnout of votes at 16. And the other thing to consider, of course, is, well, how important is that as a criterion in deciding whether votes at 16 is a good issue, is a good thing to have or not? If there's good reason to think that 16 and 17-year-olds ought to have the right to vote, is concern about turnout really a valid reason for denying that?
It's a bit of a chicken and egg, isn't it?
Well, you won't know until you try.
Sure.
Who we got? Yes.
Oh, yeah. Isabel Field, just an ordinary person. Surely, the lady there just said that now people are allowed to vote at 16 in Scotland and Wales. If you're not in England, surely that's discrimination, because it's all one country, Great Britain, isn't it? And so whether you're doing referendum about next year, you must be allowed to vote. And that's one bit. You can't discriminate like that if you're in one country. I mean, England always supposed to catch up. They were caught up in property banks and the year first. And the other thing is there any particular good reason why people get a place in the House of Lords, they have to give up their right to vote? And one more quick thing, I know the Queen can't vote, but how far down does that go? Is it just the Queen or is that near the royal family?
Shall I?
Please.
So the Scottish Parliament has enfranchised, as Isabel tells us, voters for Scottish Parliament elections, not for other elections.
For local government elections
Yeah.
in Scotland.
In Scotland, yeah.
Not
So,
referendum.
yeah. So it's not the case that there's a vote that takes place across Scotland and England where there's different franchise in different parts of the country. Yeah. On the matter of members of the House of Lords, so we have two chambers of Parliament, and one of them represents some people, and the other one represents other people, is the underlying. So the Lords represent themselves, the Lords, and the Commons represents the rest of it.
It's a bit more
Well, that's. I think it's fair to say that that's the principle. They've got their chamber, we've got ours.
I wanted to ask a bit about electoral registration, because this has quite a bearing, particularly on the questions we've just been discussing amongst young people, where never mind turnout, there's a concern that a portion of young people who are actually eligible to vote and therefore counted in the denominator for turnout is suboptimal, should we say. And it's going to get dramatically worse soon as well, because of the IER provisions and the decision of the government to prematurely terminate the carry forward provisions. It also seems, from experience in my own family, that the data matching arrangements don't find young people when their parents with similar data situations are matched. Back to my daughter, who didn't get registered automatically at home, although she got an NI and every other record the same as her parents had. They were matched. So it does worry me that therefore that we are going to get a big fall off of participation, whatever the entitlements are. And so you already talked about the overseas electors having very poor participation rate. But it may actually be a much broader swathe of the population, domestic population, where to be consideration as well. And more important, actually, if you look at the impact of the IER, it's bigger on underprivileged groups rather than on young people.
I was just actually, I have a question for Alan. I know that at the last electoral census, which I think came, that was 1st of December 2014, it showed that we had lost, I think something like 900,000, 800,000 people off the electoral roll, and I was. And I was looking.
Look at the May figures; they were quite different.
So I was looking for that, and I think there is some force that electoral events such as general elections or referendums do provide an impetus for elections. But I agree there are some significant administrative problems that need to be put out, and I completely agree with you that individual electoral registration does disproportionately affect vulnerable groups who don't have much contact with the electoral process. But at the same time, I do welcome the move to individual electoral registration because I think that it will have some impact on the amount of fraud that takes place in the system. But, Alan,
Yeah, so the Electoral Commission did its research after the election and came to the conclusion that it was not yet time to finish the handover to individuals.
So the further point I wanted to ask, and forgot what was international comparisons, because we're one of the few countries where registration isn't linked to other civic duties. In other words, just existing in the country at all gets you registered in lots of the world.
I don't know the evidence on percentage of the voting or of the eligible population who are in fact registered cross-nationally. It's very difficult to get good evidence on that. So I'm not sure what there is out there actually. But yes, you're right that this is an issue, and various workarounds are being attempted or being thought about at least to see what can be done in terms of, for example, universities informing electoral registration officers of who's in halls. They can't do it in the formal way that they used to, but can there be forms?
The link to national insurance has not been discussed. Was actually quite a powerful possibility.
I'm not fully up to speed on that debate.
I'm encouraged. Do trust. Just one thought prompted by the discussion.
Can you speak up?
John Carter from Google. Thought prompted by the discussion we had a moment ago about turnout rates at 18 or prospectively at 16. I think that probably turns increasingly heavily on the technology of voting that these people are required to use. I mean, people in whose lives pencils and paper now play no part are probably much less attractive to the method of voting which requires them to manipulate that technology than would be the case if something more contemporary and more electronic was available as an alternative. I suspect that's a significant factor there. But two specific questions I'd like to ask. The first one, probably for Caroline. Does it matter in which jurisdiction you're incarcerated in terms of whether or not you forfeit your right to vote? When I'm resident in England, if I was incarcerated in Scotland or New Zealand or North Korea, would that have any bearing on the forfeiture of my voting rights? I mean, the question I want to ask, the second one, is about this over-street seas voting. It seems to me, in principle, that there is some logic and some merit in the concept of reciprocity here. That countries should do deals. And if their citizens can vote abroad in other countries, then that's a right that should exist provided the same. I think the situation has always been anomalous in respect of Ireland, because Irish citizens have more voting rights in Britain than historically British citizens have had who are resident in Ireland. Now, I can see that would be a problem for some people who were British citizens but chose to be resident in Eritrea or Saudi Arabia or something. I mean, that's just the penalty you pay for living in a rather unappetising country of that kind. It doesn't seem to be invalidate the fundamental principle that there should be equality. Because if you don't have that, you end up with the anomalous situation you've got at the moment, where some people have multiple voting rights. Because as a British expatriate, they can vote in this country, but they may be resident in the country which extends voting rights to them as a resident as well. And if they're exercising both rights in the same elections, it might be the case in an EU parliamentary election, that clearly introduces to a greater entitlement on their part than is enjoyed generally, or in principle to be a bad thing.
Okay, well, perhaps if I can address your question about jurisdiction. It sounds like an interesting world tour that you're planning to result in being incarcerated in all these different places. I think I'm not aware of any legislation that takes into account what effectively would be current prisoner or former prisoner status in another jurisdiction when determining your right to vote in your native country. And what I would think as a practical matter is actually be more likely to be affected by residency requirements, so that if you did end up in prison in New Zealand for a sufficiently long term to lose your voting rights, you would be in the same position that I am, a New Zealand citizen in the UK. I've lost my voting rights simply because I haven't been home often enough, but that's not because, I hasten to add, I've been in prison. So I would have thought that your prisoner status would probably more likely, and I'm just thinking from first principles here, to affect your voting eligibility in your home country if there was a residency link in your home country. But I'm personally not aware of countries that might take into account your conviction status when thinking about your voting status. So it's possible, but I don't think it would be directly linked to prisoner status.
And on the reciprocity deals question, yes. So one thing is that it's quite common to be able to vote in two different places. So in local elections, you can vote in more than one place if you have residence in more than one place. I think I'm right in saying, though Isabel or Caroline could probably correct me, that if you're registered to vote in more than one European country, then you have to choose which one you're going to vote in for European Parliament election. Yeah. So, and just as you do for Westminster elections, the students, for example, are supposed to be honest and vote in only one of the constituencies.
It's documented, so it's possible to prosecute.
Yeah, but no one's going to check it.
There'll be a case sometime.
So the idea that you might be able to vote in national elections in more than one country would kind of fit with that and wouldn't seem to be problematic. On the matter of whether there ought to be a reciprocity principle, I mean, I'm not sure. Caroline's much better on this sort of thing than I am, but I mean, I would have thought that it's if we want to give the vote to any Kiwi who's resident here, then that's our decision. If the Kiwis want to stop us for a year, then...
And I think it's really... I don't think that it would need to be at the level of some kind of bilateral treaty like we do with tax. It would just be up to the decision of the national parliament to decide who it wants to enfranchise. And certainly if you went to live in New Zealand for a year and became a resident, then you would be eligible under New Zealand law to get the vote, just as I am eligible under British law to vote here. But I don't think there is any... Sorry?
Subject to your immigration status.
Yes, that's all perfectly fine. I just hasten to no irregularities there. I have passed my life in the UK test and got the right stamp and passport. I think that's a matter for national parliaments to decide, and they do vary, as your statistics have shown, at how generous they are with granting the vote to nationals, non-nationals. So I think I can't discern any principle on reciprocity.
Hi, my name's Elise O'Brien. I also work in the House of Commons Library. I was just wondering if I could pick up on the question about being imprisoned abroad, because I'm not sure I understood your answer. But say I was a British citizen and I was convicted for a crime in, say, New Zealand, but I was living there in that prison for less than 15 years, so I would still be enfranchised in the UK. Would I be able to vote?
I think so. I think so.
So it's only people who are imprisoned in the UK?
Yes, yes. Yes, so if you are thinking of doing something naughty and you want to vote, then my advice is to not do it here.
On the question of
Colin first.
on the question of mutual voting, there are already rules which appear to be mutually contradictory between nations on this, and therefore I think the answer to the reciprocity idea is impossible. Just to give an example, I've come across through being a councillor in Cambridge for many years, a lot of student electors, Commonwealth citizens all entitled to vote here, so EU citizens in this local elections. Malaysian citizens are instructed by their government not to vote here. For example, they're instructed to vote in Malaysia. So under the law, the domestic law that they're subject to in this country, they may vote, but they may incur penalties in their own country. And I'm not quite sure that I'm very sure that's not the only example. Similarly, the Americans take the view that American citizens will vote wherever they are, and therefore they don't care what anybody else's law says about it. As far as they're concerned, they're Americans and they can vote. I just see no grounds on which to get any reciprocal arrangements in those sorts of attitudes.
That's sorry, it's very interesting. So is I just want to probe a bit further on that. Is there a provision in Malaysian law that prevents them from voting?
I don't know the basis of this. I've been told it by
very
Malaysian
interesting.
students over the years.
Wow. I mean, they're
maybe it's just an excuse not to vote.
I just tried to think of any reason why that would be the case.
Okay. Lewis.
Doesn't devolution and expat voting create a number of quite strange anomalies? I mean, for instance, in the Scottish independence referendum, a Scottish person who had taken a job lasting a couple of years in Cambridge, Massachusetts would be able to vote, but not one who took one in Cambridge, England. And indeed, even if a Scot in prison in New Zealand would be able to vote, whereas a Scot working in London wouldn't. Now, I can defend this on the grounds that it's administratively difficult to sort of pick out Scots in England and Wales and Northern Ireland who have a legitimate claim to vote. I can't really justify it in terms of a principle. And it could be important. I mean, in the same way that British citizens in the EU may be pro-EU, Scots working and living in London for a bit may be particularly pro-union. So it may have effects on outcome as well.
I could vote in the 1997 Scottish election because I was living in Hungary at the time, having previously been living in England for several years. I was a student in England during which, had the referendum taken place then, I wouldn't have had a vote in the Scottish referendum, but then I was a student in Hungary, and for that period I was registered in Scotland, and therefore I could vote.
Well, as the only member of the audience probably to have visited North Korea, I just regardless of my age, as to whether there will be any point in my having any eligibility to vote in the North Korean election. Though we all know it was a 102% vote turnout, because the current president, of course, has been dead 21 years, and the outcome is a foregone conclusion.
The competitiveness of elections matters as well as inclusiveness of
Okay. No last burning questions waiting to come. May I thank our two speakers very much on your behalf for two very stimulating presentations and for dealing with all your very wide-ranging questions afterwards. Thank you very much indeed.